Wednesday, April 30th at 8:45 in the morning, and I'm going to try and give as concise an account of these civil rights cases as possible. There's 3 cases. I'm listing them here. One is currently in Lynn County, Isaac v. Oregon, also Isaac v. Renee Perry. That's in Lynn, which I filed first. The second 2 are in Benton right now. That is Shelley Bosshart Davis and Brett Haynes, the Oregon legislative assistant. Now, all 3 of these, Renee Perry, Shelley Bosshart Davis, and Brett Haynes, they're all employees. They're paid by the state. Shelley Bosshart Davis is my representative in District 15 of Oregon. I voted for her. But since they're paid by the state, they are state employees, including my representative, and I only had their work address to serve them notice. So I had to go to Marion County, which is Salem, pay them to serve the defendants at their workplace, which is on state grounds, but the Marion County sheriff can't do that. By crossing the threshold to state property, they had to give it off to the Attorney General Dan Rayfield, I think. Now, if I understand the process correctly, all of that's just automatic. I don't have their personal home addresses. I don't want to pay a private eye to find them. So it had to go through the Attorney General because it's just a process. And this is where it gets good. The Attorney General assigned it to Assistant Attorney General Becky Miley. Now, because it's a small claim, they cannot represent the defendants in small claims, but they can request to appear in court with a non-attorney representative of the Department of Justice for all the defendants, which they requested in all 3 cases. They also requested to be named the sole defendant, the state of Oregon, the sole defendant in all 3 cases, and they sent all their motions to all 3 cases at once while I was on vacation or coming back from vacation. So as soon as I found it, I discovered that a paralegal by the name of Michael Hosselton, who is a Department of Justice employee, public employee, just like everybody else, working for the state of Oregon, he's the one who's appearing for the defendants or is working this case on behalf of the state of Oregon in shielding these defendants from Title 42, Section 1983 of the U.S. Code. So Section 1983 is also known as the KKK Enforcement Act. It was passed in April of 1871 to protect American citizens, black, white, male, woman, American citizens, from vigilantes who at that time called themselves the Ku Klux Klan and who were frequently sheriffs or deputies or police officers, and they would, under color of law, go out and enact their version of justice that infringed on a number of constitutional rights, the pursuit of happiness, liberty, and life, right? And so the federal government, after the Civil War, they said, when the Ku Klux Klan was trying to enact their version of justice, the federal government said, no, you don't get to do that. Section 1983 says any individual who under color of law, statute, or custom or tradition, like our state laws, like the federal law, like the Constitution and the 10 Amendments, anybody who pretends to be a person representing that, the Constitution, etc., and who does something contrary to that is a vigilante and incurs a liability. The language which I'll put up here is every person. You can sue them in a civil court and have a civil claim, even if the criminal justice system never comes after them. So that is the Enforcement Act of 1871, the KKK Enforcement Act, also known as Section 1983. Now, I was not physically harmed. I was not, my property wasn't taken. But the nature of the Constitution is that it shouldn't rise to that level. There are things below this that happen before someone starts taking that step of depriving you of life, liberty, or happiness. And that's why we have bias crimes, we have intimidation crimes, all these things that are lesser than life, liberty, and pursuit of happiness. And so 1983 and vigilantism is important because Section 1983 says if you have good reason to believe that someone is depriving you of, say, your right to speech, assembly, and petition of redress, if they're doing that, you can sue them in court. That's what 1983 says. You can sue them personally regardless of their position. So when the state of Oregon got involved through some process, whatever, they were in effect saying, wait, we want the interest that our defendants are asserting. We want to be a part of that. We're going to defend them. We're going to shield them from whatever it is, this guy, Logan, this private citizen, whatever he's alleging. We don't want this individual to be personally liable. And in Lynn, they succeeded. The Lynn County judge granted the motion to name the state of Oregon as the sole defendant within 24 hours. Lynn also said yes to basically everything. And so now this case, all three cases are proceeding with the state of Oregon defending the interests of the defendant, which is vigilantism, which is taking my rights away from me, not because of some law or statute, but citing law and statute. Now remember, my original complaint was Renee Perry threatened to call the state troopers on state grounds, the enforcement agent of government. She represents the legislative agent of government, but it's all government. And so what Perry did, and this happened in Lynn County Court yesterday or the day before yesterday, I can't remember, where they called the sheriff on me. That is the government, the enforcement agent, and judicial and or legislative buddying up, teaming up to suppress the rights of the sovereign public agent. Public sovereignty, popular sovereignty is the only thing that's unique in American democracy when you compare it to others. That we, the people, are the source of their power. But once they get power, instead of using it through the Constitution and laws, they're going to say, no, we don't want to do that. Oregon is now saying vigilantism is okay. That we're not going to enforce laws or statute, but we're going to use the color of law, the appearance of law, to disguise what we really are enforcing. And that's why I said the other day, after my encounter in Lynn, what are the enforcement agents enforcing? When Renee Perry called the state troopers, when the Lynn County employee called the county sheriff, what are they enforcing? What law? Because as soon as the police are called, someone has used the law to disguise potentially unlawful acts. And the state of Oregon is saying, we don't give a shit about the Supremacy Clause. We don't care about federal rights. Instead, we want to cut a private citizen off, and not just any private citizen, a veteran whose labor produced this thing we call freedom. And that's why I've said in other videos that there is a self-destruct mechanism built into this case. If the state of Oregon can assert a right contrary to the Supremacy Clause to undermine the Constitution, the First Amendment, who do you think would like to know that exists, and who do you think would use it? I don't want to find out the answer to that question, but I do have some suspicions.